Hey there, this is Pat Ennis of Ennis Legacy Partners. I'm here with co-host Walter Dial. Our mission here on the podcast is to provide you, the business owner, with subject matter expertise on topics pertaining to building transferable or sellable business value, and then for planning your eventual exit from the business. We want to help you build a business that's transferable and then exit successfully on your own terms and conditions. One of the exit routes that's common with our clients is a sale to insiders or an internal transaction. A sale to insiders being, it could be a sale to key employees, the management team, family members, co-owners. And if you go down this route, take this strategy and work toward it, there are not a few significant things to plan for when moving in this direction. For example, how central is the selling owner to the business, and how does their role need to change? Do the insiders actually want to be owners? A lot of times owners will assume that the insiders want to be owners when they really don't. And if the insiders do want to be owners, are they suited for ownership? They may be fantastic key employees, but they could end up being terrible owners. So that's something to think about. Is the business cash flow strong enough to support an insider transaction? Is there a management team in place that can take the business to the next level while at the same time paying the selling owner? Those are just a few things. And then there are many more issues, including, of course, legal ramifications, legal documents, and so on and so forth. And that's today what we want to focus on in today's conversation: the legal do's and don'ts of internal transactions. And our guest today is Paul Schwinn. He's co-chair of the Startups and Emerging Growth Companies Practice Group at Shulman Rogers, based here in the Washington, D.C. area. We've known Paul for a number of years. Paul works with clients across many industries, including tech, hospitality, oil and gas, biotech, government contractors. He provides counsel to early and late stage venture capital and private equity financings, buy side, sell side mergers and acquisitions, reorgs, joint ventures, early stage matters. And his clients basically view him as an all-around business and legal advisor, somebody that we respect and we're happy to have with us today to discuss this topic. So, Paul, great to have you with us. Welcome to the podcast.
Yeah, honored to join. And, you set me up better than I think most of my colleagues could. So thank you for the warm introduction.
You're welcome. Yep.
Hey, Paul, great to see you. As Pat mentioned, you and I go back probably over a decade. We've had a number of clients in common, and you've always done a great job for them. So I've always appreciated it and enjoyed working with you. So thanks for joining us today.
Yeah, feelings mutual. It's nice who would have thought a decade ago or so when we met? On our first transaction was actually an internal transaction, if I remember correctly.
Yeah.
So really excited
right.
for this conversation.
That's right. So let's start off. Let me just take care of one thing right off the bat, which I'm sure we all agree on. And our listeners, Pat and I have been doing this for a long time, so we have some very faithful listeners. And if they've learned nothing else from us, I think the one thing they have learned is that you don't ask your divorce attorney to handle your internal transaction. Would you agree with that?
Yeah, I mean, unless you had a really inexperienced divorce attorney who, really is a corporate lawyer. As long as your divorce went well.
Lawyer answer. He finds the one loophole in the thing. Did you notice that, Pat?
Yeah.
So, okay, so we know a big don't is using the wrong attorney. What about timing? Pat and I, we always stress, you want to start early. But when it comes to an internal transaction, do you see a timing difference for your involvement versus sale to a third party? And when do you like to be involved?
Yeah, what I love about internal transactions is that you have a little bit more time to plan, and there are more external circumstances that can result in ultimately getting some liquidity. What I mean by that is, if the three of us started a business today, I'd want to get some sort of buy, sell in place, operating agreement in place. God forbid somebody wants to retire, or God forbid somebody passes away. That can have a material disruption on the business. So if you're the type of business that, I mean, I would argue, even if you want to sell to a third party, it's important to have that contingency planning done at the outset in case of the unexpected sale, if you will, which is probably the death of the founder. So never can be too early. Walter, the deal that you and I worked on, that was now on its third generation, and the first generation passed to the second generation over a period of 8 years. That took a lot of time and careful thought and planning and how they were going to do that. So you can never really get too early, because ultimately what you want to do is make sure the company is able to sort of transition if the founder passes.
Yeah, and so with some of the docs that you just mentioned, um, Paul, if you what are some of the do's and don'ts? Let's just start there. A do when it comes to it, clearly getting the documents in place is a do, and hopefully sooner rather than later. What are some of the other do's legally in regard to any of the docs that you just mentioned or any others?
Yeah, framing it as a do or as a don't, one thing is, okay, so getting it in place, right? You certainly do want to get something in place as soon as you can. This assumes you have either multiple founders, but even in the instance where you have a single founder, I'm working with a client right now, perfect health, 51 years old, has a super simple single member operating agreement, but we spent 3 hours talking over the last couple of weeks because if he were to pass away, he's divorced, so he doesn't have a significant other to pass the business to. His kids are 7 and 11 years old. He can't really leave them with the ideas for, or, to trust them to move the business forward. And he doesn't really have anyone internally that he said he was, ready to run the business with. So getting some plan in place for what if is definitely important regardless of circumstance. Um, Another thing that's definitely important, this is another don't, is once you are able to get it drafted and finalized, don't leave it in the filing cabinet. This is a living, breathing document, and businesses change over the course of a year, 2 years, 3 years, certainly 5 years. So it's going to be a big process to get this thing documented, but just don't then leave it in the filing cabinet. Open it up, look at it every couple of years, because their circumstances could have changed. You want to make sure that you're getting the exit that you want, as you said before.
Yeah, that's a great point right there, because we run into that quite a bit, where we'll get a new client, and one of the first things that we want to do is take a look at their business continuity plan, because more than likely they haven't in quite some time, and that's almost always the case. And if they do have if it's a partner, there's partners and they have a buy sell agreement in place, if they have one in place, it hasn't, and it's understandable. uh, but they haven't looked at it in a long time, and we read through it to notice that, hey, you know what? Based on what you told us in regard to what you would like to happen now, this document, the way it's written 20 years ago, doesn't represent that. So that point you just made about regular review of these documents, we suggest at least every 2 to 3 years. What you have any best practice recommendation regarding review?
So generally, I would recommend 2 to 3 years um, looking at your document, unless there's another intervening event. So if you have another member that joins or another member leaves, which is a common occurrence, one thing that's often overlooked are the voting thresholds to approve certain items. So by default, assuming you don't have managers, a general action would be approved by the holders of a majority of the percentage interests. So you got 3 owners, they all own 33%. You'd need at least 2 of them to approve something. Some items, such as incurring indebtedness or entering into a new lease, they require a higher threshold. So let's say it's 75%, something like that. When you have a member leave or a new member comes in, that shifts the voting requirements, right, a little bit, because our percentages will all change. And you never want to find yourself, in my opinion, in a situation that requires every single member to approve something, because that gives a lot of leverage to somebody who has a very small percentage of the business. So every time that ownership changes, look at your documents and make sure that the voting requirements and the approval requirements all sort of align with what you're expecting.
Yeah, is that voting requirements piece, would that be an example of something that would be easily overlooked by a general practicing attorney who was asked by his or her uh, client to draft the document? I mean, it sounds like it would be. I mean,
Yeah, I never want to cast aspersions. I'm not certainly an expert in all facets of the law, but I'd say I look at between 10 and 20 operating agreements in a given 2-week span. And so there's a lot of pitfalls for the unwary. And look, lawyers are creatures of contract. We all operate off of a precedent. If we get a good precedent we like, we use it again in the future. And that precedent development is an ongoing process throughout the entire career of a lawyer. So if I've done one deal in the biotech space, I might hold myself out as a biotech lawyer, but I won't know the regulatory intricacies and things that can really impact. My precedent might not be great. So long story short, if you've got a general practitioner that just has worked on one operating agreement in his or her career, they're going to pull that off the shelf, present it to you without any sort of discussion or ways that you should sort of discuss certain provisions. And that's usually a really good sign about, whether you've got just a lawyer that's drafting something or a true advisor. When you've got a true advisor, that first draft has a bunch of questions in the comments, bubbles, things to discuss, because there's almost infinite alternatives for a lot of these operating agreements.
Yeah. Hey, Paul, let me ask you something that kind of jumped in my head during this particular aspect of the conversation. When businesses are young, we've had situations where we get involved down the road, but early on, the owner was giving away equity. And either, the people are not, some of the people that involved in that are not the key employees that he really wants to transition to. So we feel pretty strongly about using things like phantom stock and stock appreciation rights, especially in the earlier stages of a company, just to avoid giving people real equity. What's your view on that?
Couldn't agree more. It's no secret that we've been working together for a while, so I know you've sent me a couple clients to do that. That's if I've got a founder or a group of 2 or 3 folks that have gotten together and they want to give someone some skin in the game, but that person is either hasn't been around for a long time or it's a new hire, we like to put in place a phantom plan. What I love about that is when you get a phantom plan, it's essentially like getting a bonus upon a sale of the business. It doesn't give you the rights of a member. We don't owe them any fiduciary duties, which kind of helps us in how we think about certain decisions being made. And they don't get to see the operating agreement. They don't sign the operating agreement. They're not bound by the operating agreement. And it's sort of a win-win because these recipients feel like they're part of the business. The value of their bonus goes up as the company grows, but there's almost infinite flexibility. If they leave, you can cut them out. And when it is finally paid upon a sale of the business, which is what I typically recommend, the company typically will get a deduction on that. So it's sort of a win-win instrument and sort of a no-brainer. So if you're thinking about getting equity to somebody before you cut the check or before you issue them the equity, I would suggest looking into a phantom plan for sure.
Yeah. Yeah. Let me ask you one other question, kind of along those lines. We've also had situations where someone will contact us and they're contemplating an internal transfer. And we'll start talking and we'll be like, well, have you discussed it with your key employees? And it's like, well, yeah, a little bit. And they've kind of made almost like verbal promises. What are the implications of that from a legal standpoint? Like when you start saying, hey, I'm thinking about, I'm going to give you 20% and stuff like that. I mean, how binding is this stuff?
If it's verbal, not binding, but it doesn't have to be binding to totally screw up your business, right? If you've promised someone something, they remember it. And even if you went to court and they wouldn't get it, it really impacts culture. So I've gotten countless situations where clients have been promised equity, not only verbally, but in an email, and it always comes out right before a sale. You want to avoid that. Equity is an important thing, and people listen to everything. Compensation, that's what sort of drives a lot of employees. So you definitely want to make sure you're consistent in your messaging and thoughtful about sort of all of this stuff.
Yeah, I met yesterday with an owner who wants to sell to an insider, and that was one of the first questions I asked him was, have you made any promises? And he says no. Actually, it was two of them, and they both said
Trust but
no.
verify, right?
Yeah,
Check those
right.
emails.
Hey, Paul, outline the legal documents. List the legal documents that a selling owner can expect to have in place if they're going to actually transact with internal buyers.
Yeah. So the first key document would be actually before the transaction. This is going to be an agreement among all of the owners if you have multiple owners or even if you have one. So that's the operating agreement if you're an LLC, or the shareholders agreement if you're a corporation of any kind. And that's ideally going to sort of list out the process by which someone will be bought out. So in this example, let's assume this isn't a buyout upon a death. This is a buyout, just ordinary course, retirement, I'm ready to go. That process may be set forth already in your operating agreement or shareholders agreement. Even if it's not, you can still agree to sell your business to an insider, maybe someone who doesn't even have equity today. So the list of documents that you'll typically come up with, the most key document is going to be the purchase agreement, right? That's going to say, Paul, you're paying Pat $17 million, and that'll be paid probably not at closing, right? Pat, like you mentioned, you want to make sure there's liquidity for the company moving forward. So it's a delicate balance of getting Pat what he needs to get paid without cratering the business. So the most common solution for that is to enter into a promissory note. So that's the second, big transaction document. Got a purchase agreement that actually sells the equity. Then we got a promissory note that's going to pay somewhere between 100% I've seen in some cases of the purchase price, all the way down to maybe 50% of the purchase price. And what I mean by that is if we've got a $17 million acquisition, half of it's paid at closing, the other half is paid over a promissory note. That promissory note's typically crafted in a way to make sure, again, you get liquidity for the business, enough liquidity to continue it, while also meeting sort of Pat's requirements for how much money he wants post-closing. So other documents you might have a pledge and security agreement. So God forbid, Pat, I'm not able to make the payments. You might want the ability to take back your equity. Most clients don't want that because they want to be on a beach somewhere. You might be able to take back some of the assets and sort of foreclose on them and sell them off to get it, satisfied for your purchase price. But for the most part, those are the big core documents.
Okay, so could the promissory note and the pledge and security agreement, could that be one document?
Yeah, you could put it all in one. Just make it a little simpler.
Yep. Okay. And then too, there could be a buy-sell agreement, right? Or would you have that as part of the operating agreement?
Yeah, I've seen buy-sells broken off. My preference is to keep them all in one agreement because, again, when we're going to that filing cabinet, if I pull out an operating, there have been several instances where I ask a client, hey, send along any documents among the members or the owners of the business, and they'll send me an operating agreement. And 5 months later, they'll say, oh my God, I forgot I had a buy-sell. That's also here. You kind of want to keep it in one document if you can, but that's a new trend. Earlier in my career, people would keep the buy-sell as a separate document.
Yeah. Okay. That's helpful. That's helpful advice right there. Absolutely is. Okay.
Hey,
so now, go ahead, Walter.
Okay. One question I have for you is, how many attorneys are involved? Like we've seen situations where it's just one attorney. I guess he's quote unquote representing the company. But then we've had other situations where, like, if it's a transfer maybe to one key employee, that key employee has his own representation. Is there a standard or an optimal way to do that?
You try to get a lawyer to not say it depends. Good luck, man. It depends. So the bigger the transaction, the more you definitely want every party involved to have a lawyer. My recommendation is to have a lawyer representing the seller and a lawyer representing the buyer. The one representing the seller is typically the company's counsel, and the one representing the buyer is typically a third party that might be representing the company moving forward. The reason you want to do that is, I'm like a dog, right? You tell me where to hunt and I'm going to move in that direction. And when I represent the quote unquote company, or I represent both sides, I really can't advocate for anybody in particular, right? I just have to kind of guide everybody and try to find a solution. That can be really expensive because I have to explain to both people while they're both on the phone what needs to happen. Whereas if I represent the buyer or the seller, I take a position, I take a stance, I draft things to protect my client. And we're very sort of business focused. We're not here to just run the bill up, but it's much more efficient when you sort of have direction and know who you're trying to help in a transaction.
Yeah, you know what? That's a very important point, I think, because I think a lot of times owners, sellers are thinking that it's more efficient from a fee perspective to have just one attorney doing it all. But that's not the case, is it? Because you need to, yeah, it can be much more expensive if you do it that way than if you have separate counsel.
You're also giving your lawyer a stomach ulcer. Like, it puts me in a pretzel trying to have to navigate all the different conflicts potentially. I just did one where, single seller sold to 4 buyers, and the 4 buyers didn't want separate counsel. And so I had to stand back and sort of take direction from everybody. And it costs a lot of money, and I don't like that. I want it to be as efficient as possible so I can move on to the next thing.
Yeah. Okay. So in the last number of minutes we have left, our listeners like stories, like I like stories. You like stories. We all like stories. Are there any do's and don'ts stories from a legal perspective that you can share? It'll probably be what they remember most.
Cool. Yeah. Not to be dark, I do have one that comes to mind, and this is a form of an internal transaction, but I always call it sort of the death spiral. And this is something I'm always looking for in a buy-sell agreement when it's presented to me and they say, oh, my trust and estates lawyer put this together. The first thing I flip to is what happens upon the death of the key sort of driver of the business right now. And what will sometimes happen, Pat, I don't know if you all will advise folks to do this, but if you do, I think we've done a deal where this wasn't the case. But long story short is there was a trend where upon the death of the founder, if you will, the other members are obligated to buy out the founder. So it's mandatory, not optional. And the price is set by the trailing 12 months or past performance of the business. And the purchase price is paid at closing. So mandatory buyout based on a prior formula, and it's mandatory to be closed at all at the same time. I've never seen a business make it through that. It is the death knell, because what happens is you lose one of your top producers immediately. The business is automatically worth less than what it was the day before they passed. 2, it's a mandatory buyout, which means you have to follow the provisions in the operating agreement. And the operating agreement doesn't always account for a promissory note. So you have to come up with this huge slug of money based on a valuation that doesn't exist anymore, and you totally crush the business. I can't tell you how many times I've seen that and immediately sort of moved to a different sort of approach for this that still finds a solution. So life insurance can be a really key provision there. Pat, I'm sure you guys work with that as well.
Yeah.
So.
And the life insurance piece, there was a case, Connolly versus the U.S., right, where the life insurance was actually the proceeds, because it was a stock redemption plan. The proceeds was included in the valuation, the final valuation of the business, and that was a big shocker to the remaining shareholders.
As an increase to the purchase price? And
Yeah.
then they separately value the business? Wow.
Yeah.
All right.
The U.S. Yeah.
So, ultimately, it's up to the parties, right? Like, it's, creatures of contract. You can do whatever you like, but, again, as you said.
Okay. What's another story that was maybe on the other side of the ledger? Everything went well, and maybe it's something that you put together. Of course,
yeah.
It's something that you designed.
Oh man, let me just pad my pockets here.
Maybe even with our help, but some wonderful story that went well that you can put forward as a good.
I'm really proud of one of my mutual clients that I have with Walter. Walter sent them to me, nearly a decade ago, and it's my golden child for a successful, transition of a business. So this client, government contractor, you got generation 1 who's probably in his late 70s. You got generation 2 in his 40s, and another guy in his 30s, and they just had it all thought out, meticulous detail, very thoughtful clients about how they wanted these things paid out. And the first generation was bought out over several years, and it was just a great example of somebody really thinking ahead to make sure that their business was able to transition. They got the right people, the right team, and I'm not going to credit myself. I kind of came in sort of midstream of Gen 1 transitioning to Gen 2, but with them, under the tutelage of Walter, we're able to get a phantom plan in place, transition from one generation to the other, and the business has only grown from there. Litigation can crush these things, right? Not having a thoughtful transition can crush these businesses. And so, I really credit Walter and his team with kind of orchestrating and sort of, architecting a really nice transition. So now they're on generation 3, right? They're in mid generation 2 to generation 3. And it's nice when you don't hear from your clients because it means things are going well.
Yeah, good. Yeah, we just recently had a situation just pretty much like that, where some two partners based in Chicago. We've been working with them for about 3 years and putting all of this in place. And they, fortunately, they did have a very skilled, knowledgeable Chicago-based attorney who, like you, this is what they do. And so we were able to work with them and put in place an extensive business continuity plan, including made sure their estate planning docs were in place and all like that. Insurance. Well, this past year, one of the two partners passed away actually it's the beginning of this year, from stage 4 cancer. And so it was wonderful. That wasn't wonderful. Of course, that was tragic, but it was, everyone knew it was coming. And so still tragic and very emotional time, of course, as those times always are. However, what did help was the plan was in place. The spouse was taken care of the way they needed to be taken care of. The business is continuing the way it needs to be continued. The surviving partner had everything in place to make the estate whole. It was just it was wonderfully done, and so we just recently experienced it and we're very blessed to be a part of it.
Yeah. Congratulations.
Walter,
It's
do
nice
you
when it
have
goes
any
that way.
remaining questions for our friend Paul today?
No, I think this has been really good. As always, Pat and I get to learn some things, and I'm sure our listeners really appreciated your knowledge and insights, Paul. So thanks so much for joining us, and we'll definitely have you back. Great to see you.
Yeah, for instance, the your preference of having both the operating agreement and the buy-sell agreement as one document, that makes sense. And I hadn't really thought of that before. And so that's helpful, because typically, historically, we've kind of liked to see them as separate documents, because when we have seen them together, they've been almost always deficient and not enough detail in either. But as long as you've dotted the i's and crossed the t's, it does make sense to have it in one document.
Easier to swallow if they're separate agreements because it's two, 20 pagers instead of one 45 pager. But I can't tell you how many times I've read a buy sell that sort of flies in the face of the operating agreement, even if they're intended to kind of work together. But there's situations where I've got a multi-member LLC agreement. I have everybody sign an operating agreement. If there's a buy sell just between two of the owners, that can be a separate thing because you don't need everybody seeing your separate agreement. But yeah, a lot of nuance, a lot of fun. Really, really honored to be on here, and thank you so much for having me.
Well, any final thoughts? And then we want to ask you to provide your contact information for anyone who wants to reach out. And then if there's anything that you want to promote today, but before you do that, any final thoughts about anything that we've talked about here today?
I got a little sticky note of all the things I wanted to address. I got every single one of them. So,
Okay, all right. Okay,
no
good.
final thoughts. I think these are really great questions, and yeah, excited to work together further.
All right, great. Then if someone wants to contact you and anything that you want to promote.
Yeah, you can reach out to me. Check my website. If you Google Paul Schwinn, Shulman Rogers, SHULMAN ROGERS, you can find my email on there. I won't type it out for you now. And always happy to help. Free consultation for the first, conversation. I'm been here 11 years, going to be here for the rest of my career if all goes well, knock on wood. So, even if you're listening to this podcast a couple years from now, you shouldn't get a bounce back email when you send that. In terms of promotional things, let me think. We've got some really exciting stuff happening from Schulman Rogers Next. That's our startup program, an emerging growth company program. It's flat fees for early stage companies, so you know exactly what you're going to pay for the first 10 things a startup needs to do. Formation package, employment package, intellectual property package. Just this week, they were up in New York, got second place in an award ceremony for enabling startup success. We were against Wilson Sonsini and some of the biggest, law firms in the nation. So super proud of our team for kind of putting that one together. So keep an eye out. Go to srnext.com, I believe is the URL for that, and you can see what type of events we have coming up in the area.
All right, fantastic. Paul, thanks again for joining us. We'll have you back again. And listeners, if you want help in maximizing the value of your business or planning for your eventual exit, please contact us at Ennis Legacy Partners through our website, exitreadiness.com or nslp.com. Either one of those works. Thanks for listening, as always.